One.
Hello, good night. Welcome to Legalize.
Yes, good night. Thank you.
As we continue the mission of Legal Eyes to provide legal information and legal education to the public and to thereby bring law closer to the people, as we pursue the aim of making our people better and more informed consumers of legal services, be it at the micro, individual level, or the macro, state/societal level, as we strive to assist our people to better understand the legal system as part of the social ecosystem. We are pleased to have with us tonight the President of the Caribbean Court of Justice, the Honourable Justice Adrian Saunders. Tonight's program is being co-hosted by well-known Caribbean attorney at law, Ruggles Ferguson KC, who many describe as the unofficial dean of public legal education in the Caribbean. Without much delay, and as I just give, as I recognize the sponsors of the program, after that we will introduce our guests. The sponsors of this program are Gel Professional Solutions, also Gem FM, carrying this program out of Canada, and Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
So, welcome to my co-host and welcome President Saunders. Thank you for agreeing to appear on this program, and once again, welcome to my co-host.
Yes, thank you.
I don't need to introduce the co-host, but I will let him have some introductory words.
Yes, thank you, Brother Layne. And of course, welcome, President Saunders, your first program on Legalize. And again, as we always say, in the region, it's important that we have public legal education, and especially as it relates to the Caribbean Court of Justice, established in April 2005. We are approaching the 20-year mark of the court. In fact, next year, April marks 20 years of the existence of the court. And though we have most countries being part of the original jurisdiction of the court, we only have 5 to date being part of the appellate jurisdiction of the court, being Barbados, Guyana, Belize, St. Lucia, and Dominica. And I think it is extremely important, in fact, that our citizens of the region who will participate in certain countries through referenda to decide whether or not we adopt the court in place of the Judicial Committee of the Privy Council, it is very important that we have this continuing legal education, continuing sensitization in relation to the court. And we can hear it from no better individual than the president himself. So welcome, President Saunders. Welcome to the show. And probably we can start off, as I mentioned, original jurisdiction and appellate jurisdiction, because it is said that the CCJ comprises two courts rolled into one. The original jurisdiction of the court and the appellate jurisdiction of the court. So maybe we can start off getting the distinction between those two jurisdictions.
Yeah, thank you very much, Ruggles, and thank you to Ewart for your introduction, and also for the work you're doing in public legal education. Particularly, CCJ is extremely pleased to be able to have this opportunity to explain a little bit about its work, about its methods, because that is very poorly understood by quite a lot of people in the Caribbean. And that is a great pity, because the Caribbean Court of Justice is the Caribbean's court. It's the Caribbean's premier court, in the sense that it is the court of final instance for those states that amend their constitutions in order to permit it to perform that role. But also, it is a court that interprets and applies the CARICOM Treaty, the treaty that of regional integration among CARICOM states, and which in many respects govern different aspects of our lives, even if we don't fully understand or appreciate it. In terms of what the court is established to do, and the two jurisdictions that it serves, we have, as you pointed out, an appellate jurisdiction. Appellate comes from the word appeal, means that when you have a matter in court, you go before a magistrate or a judge, and you get a decision. If you are dissatisfied with that decision, then you can appeal it to the Court of Appeal. In Grenada, you would go to the Eastern Caribbean Court of Appeal. If you get a decision at that Court of Appeal with which you are dissatisfied, then you may have the right to go to another appeal court. Currently in Grenada, that other appeal court is the Judicial Committee of the Privy Council, which sits in London. And for those countries that have amended their constitutions to cater for the CCJ, that second Court of Appeal is the CCJ. So in our appellate jurisdiction, we hear appeals from the courts of appeal of the countries that send their appeals to us. The other area of operation or jurisdiction that we have is where we interpret and apply the CARICOM Treaty. The CARICOM Treaty, that's this document here, treaty, the revised Treaty of Chaguaramas. This is a treaty entered into by CARICOM states to provide for the CARICOM single market and economy. The treaty allows for citizens of CARICOM to be able to move from one state to the other without hassle. It provides for companies to be able to establish business and to trade, to engage in sales of their services to other countries in the CARICOM without interference. it provides for a single customs union. That is to say, goods that are coming in to the CARICOM space from outside the region would pay a tariff that is set by CARICOM, and it isn't that each country would set its own tariff. So there are a number of different things that this treaty provides for. And where there are disputes concerning the interpretation of this treaty or how the treaty is applied in any particular manner, those disputes are heard by the Caribbean Court of Justice.
So, President, in other words, insofar as the court is a treaty court, it is something completely new to our region.
Completely new. We have never had a court to serve that kind of function before. So let me give you an example rooted in one of the cases that we did. One of the cases which I think is perhaps more well known than others. That's the case of Shanique Myrie. This is a lady, a young lady from Jamaica who was traveling to another CARICOM country, ostensibly for a vacation. And at that other CARICOM country, Barbados, the border officials, the officials at the airport, treated her very badly and sent her back to Jamaica the following day. And she brought a claim against the state of Barbados, where she asserted that under this revised Treaty of Chaguaramas, she had certain rights, and those rights were violated by the state of Barbados. And she prevailed. The court found that yes, she was entitled to certain rights because the CARICOM heads of government had agreed among themselves that citizens within the CARICOM area had the right to travel to each other's country for a period of 6 months. And unless it was established that they were a threat to national security or that they were going to be a burden on the state, the border officials were required to allow them entry for that period. And the court found that Barbados had breached that provision in the treaty. And so Ms. Myrie was able to get damages for the breach of the treaty and for the treatment that she received. There have been a number of other cases in the original jurisdiction having to do with the cement industry, because there is a cement manufacturer in Trinidad with branches in Barbados and Jamaica, Trinidad Cement Limited. And rules have been put in place in order to place a fairly high tariff tax on cement coming into the country from outside of the region. And TCL, Trinidad Cement Limited, brought a number of cases to protect their interests where cement was either coming into the country and the particular government was not imposing the tax which ought to have been imposed on this extra regional cement, or there were situations where they thought that cement was coming into the country but was being misclassified. And so those disputes were brought to the CCJ, and the court had to investigate the matter and to give a ruling on them. There have been other areas which have been explored in the original jurisdiction as well. We had a case from Suriname that dealt with the importation of flour, which was similar in principle to the cement case, where Suriname was importing flour from the Netherlands without imposing the tariff, the tax that was supposed to be imposed, instead of importing that flour from countries within the region. And we had to deal with that matter. So the aim of the court there is to protect the rights of businesses and individuals that have rights under the Treaty of Chaguaramas.
And that's completely new. That's not the kind of matter that one could have taken to the Privy Council.
No, you couldn't take that. As a matter of fact, there is a provision in the treaty that says that any court that is doing a case where an issue in the case involves the interpretation of the revised Treaty of Chaguaramas, the court is supposed to stop and refer to the CCJ for an interpretation of the particular provision in issue before it continues with the case. And the reason for that provision is to ensure that throughout the CARICOM area, there is a single interpretation of CARICOM rules, so that you don't have a court in Dominica giving one interpretation, a court in Jamaica giving another interpretation. That would disrupt the uniformity that is required of the application of the treaty. And so courts are required to refer matters if those matters concern a provision in the treaty, the proper interpretation of a provision in the treaty.
And when you refer to court, there you're referring to the local courts, both the High Court and the Court of Appeal in the various jurisdictions.
Any court. In fact, I'm glad you raised that, because what triggered my going into that is when Ewart referred to the Privy Council. If a matter is before the Privy Council and an issue there concerns the interpretation of a provision in the treaty, the Privy Council would be required to refer that issue to the CCJ in order for the CCJ to give its interpretation. And as I said, this isn't because the judges in the CCJ have super brains or they're brighter than anybody else. It is simply to ensure that there is a uniform interpretation of the provisions of the treaty, irrespective of where the dispute is coming from.
And the reference, let's say at the level of the Privy Council to the CCJ, involves courts that are not members of the appellate jurisdiction of the CCJ. Well, even posing the question, it means that it would not reach the Privy Council. But for the local courts, like the Court of Appeal, once it's a matter that concerns the interpretation, irrespective of whether you are part of the appellate jurisdiction of the court, that matter can be referred to the CCJ.
That's exactly right. That's exactly right. The key issue here is not whether you are a member of the appellate jurisdiction. The key issue is whether you are a member of the CARICOM community, of the Caribbean community, and whether there is an issue concerning the rules, the treaty provisions of the CARICOM treaty. But we have never had a reference so far. There have been about 3 or 4 occasions when one might say there should have been a reference. But one of the things, and a Surinamese lawyer has done a doctoral thesis on this issue, very good thesis, Jacinta Asafi. And she kind of blames us in a sense, because the possibility of moving directly to the CCJ when you have an issue has been so easy that many individuals or businesses that might have brought a claim or a case in the local courts have chosen instead to bring that claim directly to the CCJ, which they're entitled to do. And some of them do so because they believe that they will get a decision quicker, or they believe that the processes of the CCJ might be more efficient than those of the local courts. The downside of doing that is that the kind of relief that you could get, the kind of satisfaction that you can get, the damages that you can get are different if your case is brought in the local courts than if they are brought at the CCJ. And so, although the CCJ can also give damages, the threshold for getting damages in the original jurisdiction before the CCJ is more difficult than the threshold for getting damages in the local courts if you were to bring a local action and then ask for the local court to refer the issue of the interpretation to the CCJ.
Interesting.
Yes. Yes. Before we move off from the original jurisdiction, can you confirm that all CARICOM member states are members of the original jurisdiction of the court now?
Absolutely, it's
All.
you,
Yes.
you can't be you can't be a member of CARICOM. No, let me put it another way. Every CARICOM member that has subscribed to the agreement establishing the court automatically has embraced the original jurisdiction of the court. There are CARICOM members that have not embraced the agreement establishing the court. Bahamas, Haiti, Montserrat are 3 CARICOM members that have not signed on to the agreement establishing the CCJ. But all of the other CARICOM members are automatically a part of the CCJ's original jurisdiction.
Right. And the same judges we know who hear appellate jurisdiction matters, they also hear the original jurisdiction matters. If a country, is there an additional requirement, for example, to become an appellate member of the court? So, for example, if Grenada is to join the court, is there, and we are already members of the original jurisdiction of the court, is there any additional requirement, financial or otherwise, if we become a member of the appellate jurisdiction of the court?
No. But the court, and this brings us to the way in which the funding is structured for the court. It's a very novel, very unique mechanism. When the court was being established, as we have already gone through, it was established with these 2 jurisdictions, the appellate jurisdiction and the original jurisdiction. And the decision was taken that 1, the funding of the court must be paid by every country that subscribes to the original jurisdiction. So whether you were going to send your appeals to the court or you weren't sure, because Suriname, of course, have a different legal system, and they knew from day one that they could not send their appeals to the court. I wouldn't know how to deal with a Surinamese appeal because it's a different system of law. But nevertheless, Suriname's responsibility to pay was not diminished because they were able to say, well, I'm not going to be using the appellate jurisdiction. I'm only going to be using the original jurisdiction. No, every country's responsibility for the funding of the court was premised on it being a member of CARICOM in the original jurisdiction. In addition, I'm sure, I know that the state of Bahamas also contributed to the monies that went towards the fund that was established to defray the expenses of the court. Now, the way in which those expenses are defrayed, or the way in which the funding arrangements go, is that, let's back up a little bit. When the court was being established, one of the concerns of bar associations and persons who wanted to ensure that this court was fully independent financially and otherwise, was that they needed a mechanism to ensure that this was not a court which would require the court to be running behind governments every year for a subvention and running the risk that if the court gave a decision that might have been unfavorable to a government, it might say, well, look, this year I can't pay. Or running the risk that a hurricane could, do damage to the economies of one or more states and therefore compromise their ability to pay. We wanted to avoid, but those who were organizing the court at that time wanted to avoid those possibilities. And so they came up with an arrangement that was novel, unique, one which the international community has marveled about and is envious about. And that is the concept of a trust fund. They try to imagine what capital sum, if invested, would yield a sum of money that could keep the court operational for well into the future. And they assessed that this sum would be $100 million US. This $100 million US would be invested, would be managed by a group of trustees, and the court would live off the interest, off the yield from the investment. How would you pay? How would you get this $100 million? Well, the CDBs, the Caribbean Development Banks, the CDB was entrusted with the responsibility to get that money on the international market and then to lend the money to the various CARICOM countries roughly in proportion to their GDP. So that Trinidad would have to pay back, say, 27 million. Jamaica would have to pay back, say, 28, 29 million. Grenada might only have to pay back 4 million. St. Vincent and the Grenadines, 4 million, and so on, until it came up to 100 million. And so each country had to repay the CDB their proportionate share of this $100 million over a 10-year period and at a very reasonable rate of interest. So over 10 years, they all have already paid up for the court. And the 100 million was placed in the hands of trustees whose responsibility was to invest it as best they can so that the court's budget would be would come out of that investment. And that is how the court has been running. Of course, at the time when the decision was taken to fix that capital sum at 100 million, there were some issues which were overlooked. Like, for example, the fact that the court had to pay for its own security. We are located in Trinidad and Tobago, in Port of Spain, and the state of Trinidad and Tobago does not provide security for the court because the court is an international organization. So every cent that we spend comes out of the trust fund, save, of course, Trinidad having sought and been granted the privilege of hosting the court, undertook the responsibility of providing premises for the court. And so we occupy premises on Henry and Charlotte Street, which are provided by the state of Trinidad and Tobago. But outside of that, pretty much everything else comes out of that trust fund.
Yes.
Okay.
Good. And it's I think just in terms of sharing a bit of information here, that trust fund started off initially with $100 million. And we are now 20 years into the court, close to 20 years into the court. And I believe the balance on that trust fund is in the region of 70 something $million still.
But I, that is true. But quite a good portion of those funds actually are committed. And this is another area where, when the 100 million was conceived, I'm not sure was fully catered for. Quite a good bit of that 70 million has to go towards the pension payments of persons who have retired from the court, both judges and non-judicial staff. But the fact that after 20 years, paying salaries to court, to judges and staff for 20 years, buying paper, paying light bill, doing this, doing that, whatever, for 20 years, and still having that amount still left, shows the wisdom of financing the court in this fashion.
Yes, it's a lovely structure, and it deals with a lot of the risks. Although I must say, some may argue that the fund should actually be growing rather than diminishing. Although
that is true, and that is a function of the fact that, as I said, the 100 million in hindsight was too conservative a figure.
Yes, and we also have to take into account the international economic climate and how we are affected this side of the world when we have, for example, the 2008 crisis, and all of these variables that impact. But at least what we are hearing is that over the last 20 years, close to 20 years, because 20 years, April 2025, the court has did not have to depend on governments directly to fund its operations, and I think that is a critical feature. If I'm not mistaken, is the CCJ the only court internationally? Is there any other court that has that system set up, to the best of your knowledge?
I don't know of any other.
Yes.
That has a system like that.
Yes. Well, I think what we can probably do is, because it's a public education program, and these programs are targeted mainly at the public, we can look at some of the concerns that members of the public have in relation to the court, and probably get your responses. For example, there are concerns expressed about the independence of the court, and I even heard up to recently some comments made about the court and the influence of politicians, possible influence of politicians in these very small societies that constitute the Caribbean civilization. Can we get your response to that, the independence of the court, and what you have to say on that?
Let me tackle it, first of all, from an overarching standpoint. A little while ago, we went through the original jurisdiction. We didn't mention that in the original jurisdiction, states of CARICOM also have the right to bring proceedings against other states of CARICOM. We had a case once where the state of Belize brought an action against the state of Trinidad and Tobago. And I think that there was another case that we did where one state, certainly in the case of Shanique Myrie, if I'm not mistaken, the state of Jamaica was an intervener in that state. So I reference this fact because if you have a court where the governments are likely to have litigation against each other, why would any government want to weaken the independence of that court? In whose interests would they be weakening the independence of the court? Would Trinidad want to have a court that is partial? Would Jamaica allow Trinidad to have a court that is partial to Trinidad? Would Barbados want to have a court that is partial to the government of Guyana? So from an institutional standpoint, the charge, the suspicion that the court's independence is either weak or is at the mercy of some particular government is undermined by the fact that, as I said, each government in the region, each state in the region has a vital interest in ensuring that the court has strong independence, is uninfluenced by any other government, and has the best judges that choose to apply to be judges of that court. The second thing I would say is that I have been on the court and I've been the president of the court for the last 6 years plus. As chairman, as president of the court, I am the chair of the commission. The commission, the Regional Judicial and Legal Services Commission, is the body that is responsible for hiring the judges. No government, no politician, no outside influence is involved in the selection of the judges. The commission goes about that process with one thing in mind: to have the best candidate for the court at the particular time. And as I said, for 6 3/4 years, I have been the chair of that commission. And therefore, I am in the best position to assure the public that the selection of the judges is done on a transparent, merit-based manner. The irony here is that we don't know how the judges are selected in other countries that we seem to think are better or engender greater confidence. But our system is one where when we have a vacancy, we put out an advertisement. We need a judge. If it is that the judge that we need must have special qualifications, so that, for example, we recently appointed a judge, Dr. Ononeu, Justice Ononeu, and the advertisement that went out for that vacancy, which was created as a result of the untimely passing of Mr. Justice Witt, the advertisement that went out clearly indicated that what was needed was a person who had expertise in international law, including international trade law. And she was the best candidate of the persons who applied. I reject entirely any charge that the CCJ's independence is weak or is compromised, or that the institutional mechanisms in order to guarantee that independence are any less than any court anywhere else in the world. In fact, I would say that many of the mechanisms that we have are far stronger in ensuring our independence than the mechanisms that exist in other courts.
But,
Yes.
President, how would you respond to those who say that not on the issue of independence, challenging the independence, but they are of the view that the process of selection should be much more public, so that before a member of the public learns that, for example, the recent appointment was made, that there should be some information that, listen, this process is ongoing, this person is a candidate, these are the qualities of the person, so that the process in that sense is much more public than it appears to be presently. You don't have to go as far as the American process, not as far as that, but somewhere in between.
Yeah, I understand that, and I sympathize with those views. I appreciate those views, and it is something that I have struggled with. When I pointed out how we go about filling a vacancy, we put out an advertisement, people apply. In the application process, we require certain things. We require a CV. We sometimes would require you to you would have to give referees, of course. Sometimes we require you to send us a sampling of if you had been a judge somewhere, of your judgments, or as the case may be. Now, I understand the notion that the public would like to see the court publish the list of all the applicants and perhaps the list of those shortlisted. We haven't been doing that. One of the reasons we haven't been doing that is our attempt to balance that disclosure with the privacy of the applicants. Some persons who apply don't want their current employer to know that they have applied. Some persons who have applied have a number of different reasons why they would not like it disclosed that they have applied. Perhaps we've gotten the balance wrong, but I appreciate that concern, criticism. I don't know that in any courts in the region, we don't have a tradition of publishing the names of applicants. But as I said, I understand that criticism, and if we've gotten the balance wrong, then that is something that we need to hear more discussion about, and see how we can redress it. But that is how it goes.
Yes.
I would say we could take comfort in the fact that it's still a young court, is a work in progress.
Yes.
And I guess as we walk through those things, hopefully we get the balance right, because I don't think we should go as far as the Americans with all the scandals of them that goes with that. But it's a court for the entire Caribbean, and at the end of the day, the court is for the people. That's just the concern I've got.
I certainly appreciate the fact that you've raised this issue, because it has been raised before with me privately.
Okay.
But these are issues that should be raised publicly, so that we could generate a discussion on it. You see, so this is the first time that I have been involved in a public discussion on the issue. But I appreciate the issue. I appreciate that concern. And as I said, in my own mind, I've struggled with it, but that is how we have addressed the balance. What we have done is the name of every commissioner is published on our website so that you know who are the individuals who are choosing the judges. And you are therefore able to assess their integrity and their competence. But it is true that we don't publish the names of applicants, and I've given you the reason why we haven't been doing that.
Yes, and I think one of the strong points advanced in relation to independence too, apart from having an independent entity responsible for funding the operations of the court, and another completely differently constituted entity responsible for the appointment of judges, concern the composition of these two bodies. And in a sense, it's a democratic, independent composition, because the court does not arbitrarily choose individuals. For example, for the Judicial and Legal Services Commission, the University of the West Indies is involved, the law schools are involved, the bar associations are involved, and the chief justices of the region are involved, and I believe the public service commissions also are involved. And with the trust fund, the CCJ trust fund, you have the banking sector, trade union, accounting sector, bar associations, all doing independent nominations. So I think quite apart from the independence, there is that democratic element that's inclusive and involves key stakeholders in society. So we have looked at independence, at funding, the access to justice point. And that has to do a big sell for the CCJ has been the technology, what has been described as cutting edge technology, and that links in directly to the question of access to justice. Now, I know there was a case a few years ago concerning Eddie Ventos and the state of Barbados. And I know the CCJ has used that as one of the examples of how matters are approached and how matters are dispatched in a timely manner. And it goes to the question of access to justice. You care to elaborate and share a bit on that case?
Yes, well, first of all, generally on the issue of access to justice, it is one of the areas of our operation that we pay a lot of attention to, because one of the problems with the Judicial Committee of the Privy Council is precisely the lack of access for ordinary working people. Appeals to the Privy Council cost a very crippling amount. And so we have gone out of our way to ensure that our filing fees are as low as possible, to ensure that persons who demonstrate that they are unable to pay those filing fees, we would allow them, we would waive those fees. In fact, we had a matter from Guyana on one occasion where two elderly ladies had a dispute over who was entitled to the possession of a government housing unit. And the side that lost at the Court of Appeal wanted to appeal further to us, but lacked the means to do so. And we not only waived the filing fees, but we also asked the Bar Association of Guyana to have two of their members represent each of the parties, because the side that had succeeded also was unable to pay either filing fees or to pay a lawyer to argue before us. But the technology to be able to have lawyers and their litigants argue their cases from their respective locations, whether Guyana or Belize, Barbados, St. Lucia, Dominica. Even before COVID, we had been doing this, allowing cases to be heard online, and we also live streamed those cases, so that the concept of open court, in a sense, was maintained and even enhanced, because you had when we addressed some of the more contentious cases from Guyana, for example, you had more people following those cases online that would have fit into any courtroom in the Caribbean. And they were following it live, you know. Recently, we have started to get a sign language interpreter to sign whenever we are delivering judgments, so that the hearing impaired can also participate by viewing the judgments that we deliver. So we definitely make it a point of duty to see how we could enhance access for people of the Caribbean, because I always make this point that cases that come up to a final court are normally cases where the law is uncertain, where reasonable minds could disagree about how the particular dispute should be resolved. See, when you go to a judge or a magistrate, you have a dispute, they deal with it. And the side that loses can go to the Court of Appeal to say, well, the judge made a mistake. The judge did not sufficiently appreciate this piece of evidence or that piece of evidence, or the judge misapplied the law. The judge didn't understand the law. You go to the Court of Appeal to complain about error on the part of the trial judge. When you go to the apex court, what you're really complaining about is this is a system-wide problem. This case is symptomatic of an error in the system that you, the final court, need to correct. So at the apex court level is not correcting an error in a particular case as much as it is correcting an error that transcends the particular case and is systems-wide. And so poor people have system-wide problems. It's not only wealthy people. Some of the most impactful decisions that we have given were filed by persons of average, ordinary means. And so the point I'm making is that if you have an apex court where persons of those means have difficulty in accessing, then you are running the risk of stultifying your jurisprudence, because those cases never get definitively resolved by the decision of an apex court.
Yes. Let me just take some comments from the chat there. Someone is saying there's no uniform method of judicial appointments in the U.S. In some instances, they are elected by the public. The comment is a horrible option. And Jomo Sanga Thomas is saying one of the criticisms of the Eastern Caribbean Supreme Court Appellate Division is that it is a court of concurrence. Question, do you think this is a problem, and do you think there is room for more dissenting opinions at the CCJ?
I'm not sure I understand. That
I think what he's saying that is that you have single judgments, one judgment, and most times it's unanimous, and you don't see much dissent. I think that's what he's saying, because I've heard when they comment, both at the level of the Court of Appeal and even sometimes at the Privy Council, but most of the Court of Appeal here, and at some instances at the CCJ, that people are concerned that the court operates like a cabinet, collective responsibility. In other words, a judgment is given, and there is no dissent or no separate opinion coming from a different direction, even if it is the same conclusion. And people have commented on this. Judges are hired for the individual brilliance, the individual stability, the individual grasp of the law. I think that's what he's referring to. He says, in other words, our court is a consensus court.
In our original jurisdiction,
yeah,
we took the decision in 2005 that, like the ECJ, we would give a single judgment. Now, there are pros and cons to this.
And the ECJ being the European Court of Justice, right?
European Court of Justice, yes.
Okay.
There are pros and cons to this. The cons, of course, are that, as Jomo pointed out, that you lose the ability to read what each judge on the court who chooses to write, what their views were on the particular issue. The reason why we did it is that we felt that in the original jurisdiction where we interpret and apply the treaty, it was more important that we spoke with one voice as to what the treaty meant and how the dispute should be resolved, rather than have conflicting or run the risk of dissenting opinions and conflicting streams. Again, that is a policy choice that we made. So in the original jurisdiction, you would have one judgment. Of course, because you have 5 different judges, sometimes 7, who hear the case, we are not clones of each other, and each of us would have slightly different views. So you have to discuss and discuss and discuss until you come to a consensus on a form of wording that each person is comfortable with. That form of wording might not be as precise as individually you would like, but at least it is what each of us can live with. As I said, that's a policy choice we took in the original jurisdiction. In the appellate jurisdiction, we have concurrent judgments and dissenting judgments all the time. I can't, and I don't want to speak for the Eastern Caribbean Supreme Court. Of course, I used to be on that court, but that was 20 years ago. But sometimes, and with our court, we might consider that the issues in the case are such that it is not necessary to write a concurrent opinion to say the same thing in different words. Of course, if you disagree, then you write a dissent. But where we all agree on the result and the reasons for the result, then there is no real reason for everybody to be writing the same thing, just different levels of emphasis, or different using different words. But I don't know. I've never really done a study to see the extent to which we have concurring or dissenting opinions, but we do have them pretty often.
Okay, but it's a policy decision in the original jurisdiction.
That's correct. Yes.
So if we could just hold a while, I just want to recognize the sponsors of the program, Jail Professional Solutions, Jeb FM carrying this program out of Canada on FM radio station, and also Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
And I just want to take a message here from a well-known social activist in Grenada, Dave Ned. And he says he wants me to ask you this. Can you ask the Honourable Justice to speak on the civil society representation on the Judicial and Legal Services Commission? Who is appointed? How is the appointee chosen? What are the duties of the appointee? Is the CSO, civil society organization, representation rotated through the region? How does the CSO communicate with that representative?
Okay.
A few questions.
Right. I have in front of me the actual agreement establishing the court. And among the persons, there are 10 persons plus the chairman. There are 2 persons, and I'm reading it, 2 persons from civil society nominated jointly by the Secretary General of the community and the Director General of the OECS for a period of 3 years following consultations with regional non-governmental organizations. As chair, I simply receive those 2 nominations made by the Secretary General of the community and the Director General of the OECS. I am not privy to the method of consultations that they engage in or any of the details surrounding how they come by the names. What I have done as chair is to say to them, look, right now on the commission, we do not have Belize represented. So I'd like you to take that into account. Or we do not have Suriname represented, as the case may be. I would also say to them something like, right now, we have quite a high preponderance of legal expertise on the commission. It would be great if we could have some person who is skilled in public administration or accounting or in human resource management, as the case may be. And in the 6 years that I have been president, chairman of the commission, they have responded positively to those intimations. But I can't speak, as I said, to the details as to how they go about making the selection of the 2 persons.
And there's an easy one here for you. Does the CCJ hire judges who are not from the Caribbean?
Oh, absolutely. As a matter of fact, the first bench that was composed in 2004, 2005 comprised a judge from the United Kingdom and a judge from the Netherlands who was based in Curacao. I do think that it is not a bad thing at all for the court to have on it at least one judge who is from outside the Caribbean, so that you have the views of someone who is looking in, someone who is not a part of the Caribbean and therefore brings with them a level of dispassionateness, if there's such a word, to Caribbean issues. But, there's a big but, that person must live in the Caribbean during the time, at least when they sit on the court, so that they have the opportunity to imbibe the vibes of the Caribbean culture and people. And secondly, I lost my train of thought now. There are two things. The person must live in the Caribbean, and the person must that's the most important one anyhow. If the other one comes to mind, I'll let you know. That they must immerse themselves in the Caribbean culture by living here. But I do think that it is a plus to have at least one person from outside the Caribbean. Of course, right now, we don't. Justice Heaton has retired. Justice Witt, unfortunately, passed away. But we'll see how that goes in the future.
Ruggles?
Yes, okay. On the access point, you dealt with the issue of filing fees and cost and actually getting representation through the bar associations for potential litigants unable to afford the court. I think one of the highlights, and I can speak from personal experiences because I was involved in the filing of the two matters from Grenada in the original jurisdiction of the court. And the ease of actually accessing the court in terms of filing documents. One, and I raised the Ventos matter, particularly in terms of how technology worked to dispose of that matter in basically record time. So maybe if you can just elaborate a bit about that, because I heard the point made once that somebody from Trinidad went to file some documents in the court, came up with the physical documents to file, and they were sent back and asked to have them filed electronically, which puts everybody on an even keel, whether in Trinidad or whether you're in Guyana or Grenada, Jamaica. It's electronic filing, and you can file those documents at any time of the day or night.
Yes.
So, yes.
Yeah.
Your comments.
Right. First of all, on the filing generally, in many registries in the region, if you walk into them, you see mountains of paper files all over the place. In our registry, you don't see that. All you see is computer terminals. It allows for a more efficient processing of the cases. It allows for files to be retrieved in seconds rather than minutes or hours. And it allows for case files to be shared in a very seamless way among the parties who are involved in the case. And when we turned away the person from Trinidad, it's not that we would not accept paper, but it is more efficient for the person's benefit that it be filed electronically. That Ventos case, I remember it very vividly because it was a Friday afternoon before Mother's Day. I can't remember the year. It was the year that Barbados had elections, general elections. And a little after 4, the registry called me to tell me that an urgent matter had been filed, and they think that I should look at it. They sent it to me on my email. I should look at it right away. And I looked at it. It was an application by Mr. Ventos to compel the elections officer in Barbados to register him as an elector, as a voter for elections which were upcoming in a few days' time. It meant, therefore, that if we had allowed the case to go through the normal processes, then even if he succeeded, he would have lost because the elections would have already been held and he would have been unable to vote. And so, because our filing system is electronic, the registry was able to send all the judges the documents online. I remember speaking with Sir Dennis, who was the president at the time. He was at a function, and I called him on the phone. I said, look, this is important. I've sent this thing to you on your phone, and you need to look at it. So we all looked at it, and by 7 in the evening, we all decided that we will have the hearing on the Sunday. And to cut a long story short, all the judges received, all the documents were filed. The judges received all the documents. The respondent was able to submit their responses to the application. We heard the matter on Sunday, and we gave a decision that Sunday afternoon. And we made an order that the elections officer register Mr. Ventos, and we attached to that order what the lawyers call a penal notice. That is a notice directed to the elections officer saying, warn her that if she didn't comply with the order immediately, that, well, no, we gave her a day or two to comply, that proceedings will be taken against her, hold her in contempt of court. And Mr. Ventos was able to register and vote for the candidate of his choice at those elections. But all of that could not have happened without the electronic filing platform that we had. Also, without the cooperation of Sir Marston Gibson, was the Chief Justice of Barbados at the time, and so he kindly made the courtroom available to us in Barbados because the lawyers and litigants were in Barbados. We were in our court in Trinidad, and we were connected by an online infrastructure. And so they were seeing us, we were hearing them as they presented their arguments, and it all showed the power and the vitality of electronic communication.
Yes.
Go ahead, Ruggles.
Okay. Yes. I know that time is moving on, and it's important, just by bit of comparison here with the Privy Council, the Judicial Committee of the Privy Council, because for most of the territories that have moved to all the territories, well, save for Ghana that did not have a final court, all of them before went to the Judicial Committee of the Privy Council, and the CCJ, really at the end of the day, the question is whether the CCJ should replace the Privy Council as our final court of appeal. Now, the issue with the Privy Council is that you have a matter, there are judges in the United Kingdom, and they all sit on their courts in the United Kingdom. Most of them sit on the Supreme Court, the final court for the United Kingdom. And what their task is limited to hearing the appeal and delivering the judgment. Now, the infrastructure of the CCJ seems designed for other things. For example, you have an Academy for Law within the infrastructure of the CCJ. Of course, you hear cases, you deliver judgments, and also, very importantly, we'd like to hear your comments on how does the CCJ impact positively on the administration of justice for the other Caribbean territories? Because one of the arguments raised, you hear not too infrequently, those who wish to hold on to the Privy Council will say, listen, we need to fix the local court system first before we go to the Caribbean Court of Justice. Your comments on that aspect of it. How does the CCJ compare to the Privy Council as a final court?
Okay. You touched on a couple of things there. The first is that a final court should not operate in a sense, and this might be a little pejorative, as a post office box where you send in an appeal and get a result. Because a final court plays such a critical role in shaping a country's jurisprudence that its role should go beyond simply getting a decision, however reasoned that decision might be. Final courts and the judges of final courts have a role to play in associating professionally with the courts below. They have a role to play in ensuring the efficiency of the justice sector as a whole. They have a role to play in judicial education of all of the judges in the system. And a court that functions in the manner in which the Privy Council does cannot fulfill those roles. We in the CCJ have been fulfilling those roles, even in respect of those countries that do not send their appeals to us. And so, as you pointed out, we have encouraged the formation, and we, in a sense, service the operations of the Caribbean Association of Judicial Officers, which is a body that comprises judges, magistrates, registrars throughout the region. They have biennial conferences. They have a number of training programs. CAJO engages itself in judicial education throughout the length and breadth of the Caribbean. And so it helps to, it fulfills that role of building the fraternity among the judges in the region and helping them to promoting among them a common ethos so far as justice is concerned. Same thing can be said for the Caribbean Academy of Law, that pretty much does the same thing, not just with judges, but also with the legal profession. So that is one respect in which the CCJ is different and plays a role that is different from the role that is played by the Privy Council. The idea that the CCJ should wait until the local courts are somehow fixed or there is greater efficiency at the level of the local courts is a little baffling to me for several reasons. The first is that those inefficiencies exist even while the Privy Council is the final court. So that if there is some responsibility to be attributed for the creation of those inefficiencies or for the failure to address those inefficiencies, then that responsibility should not be laid at the feet of the CCJ. But more importantly, if you're going to wait for whatever is not so efficient at the local courts to be completely perfected before you join the CCJ, then you'll wait forever.
Wherever indeed.
Because no court is perfect. Every court, everywhere, in every part of the world, has imperfections. And therefore, to argue that, well, we must wait, and like at one time someone said, oh, well, you know, you can't fix the house from the roof. You have to fix it from the ground up. Those are false analogies. Those are excuses for remaining with a court that is staffed by persons who are not from the Caribbean and who are incapable of interpreting our laws as effectively as people who reside in the Caribbean are capable. One of the things that I've often said is that in order to be a good judge, you must see from near and judge from far. And that applies to any kind of judge, even if it's a beauty contest you're judging. You must have the best seat in the house, but you must be able to be dispassionate, to be objective. Now, people associate being objective with being distanced geographically. Geographic distance has no necessary connection to objectivity. Objectivity means that you have integrity, that you are dispassionate, and that you are capable of being able to assess a problem with a certain level of integrity. You don't have to be in Timbuktu to be able to be objective. What the Privy Council is completely unable to do is to see from near, and that is, if you like the analogy to a judge, to be able to be aware of the aspirations and the nuances of the Caribbean civilization. And if you are unaware of those nuances, if you are unaware of our culture, if you are unaware of the extent and the degree to which Caribbean people hold sacred the promise which is laid out in our constitutions that bestow human rights on our citizenry, then you can give decisions which are indifferent to or not sufficiently attuned to those human rights. And this is why we in the CCJ have a very, very different position from the Privy Council on how to treat with colonial laws. Yes.
President, I wanted to come to that. I don't want to interrupt you, but I wanted to come to that because that's something specifically I wanted to ask. But I just want to see if I understand you to be saying that, listen, these problems we have that Rob spoke about in terms of delays and all of those things, they existed for a long time, even with the Privy Council being our final courts. That secondly, change doesn't take place without the intervention of some external factor, some agent that change. I mean, that's almost a law of natural science. And that I'm going to see if I'm getting you right, that you say that the CCJ, in fact, can be that agency in the Caribbean that could drive that change in our judicial culture.
But we have been doing it little by little. The CCJ the CCJ through CAJO, through the Academy, has been doing a lot to improve, for example, the criminal justice sector. I don't know how many of you have heard of the Needham's Point Declaration, which is an emanation from the Caribbean Academy for Law, which sets out a number of goals that the criminal justice sector in each country should achieve. And we're doing this, you know. The problems that we face in justice are not going to be resolved in a day, a month, a year. It takes a lot of time. The point I was making is that the Privy Council is in no position to address those systemic problems. It is only a court of the region, based in the region, working for the region, that is able to do that. And the CCJ is doing that.
Okay, good. So I wanted to ask you also now, we have the awkward situation in the Eastern Caribbean with, you have one Court of Appeal, High Court, the Eastern Caribbean Supreme Court. But in terms of the apex court, as you mentioned, we have the Privy Council in the case of Grenada, St. Vincent, Antigua, and so the CCJ in the case of Dominica and St. Lucia for sure, in addition to Barbados and so on. What difficulties have arisen with this upward situation? I think you're going to speak about the approach to colonial laws.
Yes, because that awkwardness, as you put it, means that the people of St. Lucia and Dominica could very well be, I don't want to say enjoying, could very well be experiencing at times a different level of justice than the people of Grenada, St. Kitts, St. Vincent, and the Grenadines. And we are all in one OECS. That is very unfortunate, extremely unfortunate. It doesn't affect, or put it this way, what it means is just what I said, that the people of those respective countries could be experiencing, in some instances, a different approach to justice issues than their counterparts in other countries. We mustn't exaggerate the extent to which that is so, however, but there are areas where it is so. And as I was going to speak about the treatment of colonial laws, I'm going to give a lecture on this. OCMA is organizing a lecture, and I'm going to speak about this more fulsomely at that lecture later this month. But suffice it to say that we in the Caribbean share a particular narrative. And that narrative is that we used to be colonized, we won our freedom, we have a constitution that is different from when we were a colony because it sets out for the first time particular fundamental rights. It is premised on constitutional supremacy and not parliamentary sovereignty. It is a constitution where we pay great store on the fundamental rights that are laid out there. That is our narrative. We consider that the old regime, the regime that existed before independence, where laws were made not so much in our interests, but in the interests of the colonizer, that regime must now comply with the constitution which we have established to govern ourselves. And therefore, if there is something in a colonial law that is in tension with our fundamental rights, then a court should be able to say that colonial law needs to be modified to bring it in line with the Constitution. The Privy Council says something different. The Privy Council says, no, that colonial law can only be changed by Parliament, and therefore the court cannot modify it, or the court cannot declare it void. I have a real, well, the CCJ has, in its judgments, indicated that we have a real difficulty with that position. That position does not comport with our understanding of the meaning of independence and what independence signaled, what it was supposed to achieve. There's a judgment from St. Lucia in the case of Hilaire and Chastenay, where the Privy Council said that a colonial law that was enacted to amend their civil code imported all of the statute law of England in relation to contracts, quasi-contracts, and torts, so that if tomorrow England enacts a law, the United Kingdom Parliament enacts a law that speaks about how you go about claiming for negligence or trespass or libel, or it seeks to amend or tweak something about that process, that automatically that law becomes a part of St. Lucia's law to the extent that it can be applied in St. Lucia. Some people in St. Lucia have a real problem with that because, of course, the Constitution establishes how laws are made. Britain is no longer the body responsible for making laws for St. Lucia. And although Mr. Astafan argued that point very passionately, the Privy Council dismissed his arguments. Well, I don't want to say more because we're the final court for St. Lucia, and it would be interesting to see how the CCJ would deal with that case if we have a similar issue coming up before us.
Yes.
President, actually we have run 90 minutes, but if you would agree, if we can go on for 15 more minutes.
Yeah, that's fine.
Okay, that's great. Ruggles, I think you wanted to comment.
Yes. Well, just as I know the Needham's Point Declaration, that's really big, and it has been driven by the CCJ Academy for Law, focusing on criminal justice reform in the Caribbean, bringing together stakeholders in Barbados in October 2023. From the state, private bar, police, prisons, to discuss the justice system and coming up with recommendations and implementing recommendations. And I think that should form probably a separate program in itself. It would be an interesting program. I know Justice Anderson heads the CCJ Academy for Law. The other thing, I just wanted to take the opportunity, in fact, as Justice Saunders mentioned, the OGBA activity that's on November 26th. It's the third in the Distinguished Lecture Series of OGBA. And it's an open event, by the way, it's not for lawyers, and that will be carried by UETV, and there'll be several links going out shortly. Already gone out for those who are interested in that lecture that will impact not just lawyers, but in terms of the general public understanding the legal system and some of the important differences highlighted by Justice Saunders. I just wanted to, it relates to access to justice too, and the number of matters going to the final court. I don't know if Justice Saunders has with him the statistics, but for example, the Barbados joined the court in 2005, basically founding members Barbados and Guyana. At the time Guyana joined, the Guyana Court of Appeal was the highest level of court. But do you have an indication with the countries that have joined the Caribbean Court of Justice, whether the number of appeals to the final court has increased as a result? Taking any example, Barbados, for example, whether the number of appeals coming to the CCJ is more than what went to the Privy Council when the Privy Council was Barbados' final court, or any of the other courts. I don't know if you have any statistics with you.
I don't have the precise statistics with me now, but I can tell you that the answer is a resounding yes. The volume of appeals for each state that has delinked from the Privy Council and now sends their appeals to us, that volume has shot up tremendously. In some countries, it's as much as 3 times as much, 300%. So that if Barbados was sending 2 appeals a year, they now send at least 6 or more. Same thing with Belize. And I am sure that in the time that St. Lucia has been with the court, which is a little over a year, the volume of appeals to the CCJ has been a lot more than the number that used to be sent to the Privy Council. And it's natural because, as I said earlier, it is very expensive to prosecute an appeal before the Caribbean Court of Justice. And so that is a system that stifles appeals from persons of ordinary means, when in fact the CCJ goes out of its way to facilitate appeals from such persons.
There's a question here. Has the CCJ been able to develop a Caribbean jurisprudence over its 20 years of existence, which demonstrates a departure from the Privy Council?
Yes, well, in that area that I spoke about, which is an overarching area, the way in which we treat with colonial laws is very different from the way in which the Privy Council deals with those laws. That is the most striking departure. In some areas, we have sort of added some nuances, like, for example, on the area of the mandatory death penalty and Pratt and Morgan. Pratt and Morgan, of course, is a case which the Privy Council decided in, I think it's 1993 or so, where it was decided that you can't leave a person on death row indefinitely. And if they're on death row for a period of over 5 years, then the courts will presume that that period is inhumane and will require you not to execute the death penalty on them. We have not departed from that jurisprudence, although we have, in a decision which we gave in 2007, I think it was, or 2006, we have said that the states must hold on any execution until the person has completed their international petition process, because a person who has a death penalty can, and who has exhausted all their domestic avenues, is entitled to go to either the UN Human Rights Council or to the Inter-American commission in order to further complain. But I have no doubt there was an area where we thought we would differ from the House of Lords, but we were divided 3-3 on the issue. It was an area of insurance law. This came at a time when Mr. Justice Witt died, and so we didn't have his opinion. But in insurance law, there was a very heated debate about what a person who applies for insurance is required to disclose. What is the test for materiality? They must disclose everything that is material. What is the test for materiality? Is the test everything that the insurer would like to know, or is the test everything which would make a difference to whether the insurer would insure you or charge a higher premium, as the case may be? And the House of Lords had said it was the former, and 3 of us said it was the former. 3 of us said no, it was the latter. But the decision was not dependent on a resolution of that issue. So hopefully in some other case, we will be able to resolve that issue. But why over time we would have these divergences from the Privy Council is because we see the law through different eyes. The Privy Council judges, as I said, they see the law through a perspective which is different from the way in which Caribbean people trained in the Caribbean, living in the Caribbean, would see the law. And because of this, it is not unnatural or unusual that you would have differences emerging. But for now, there aren't a whole heap of differences. In fact, the existing laws issue is the main one at this time.
Yes. I don't know if you can. Someone is commenting an outstanding session with Justice Saunders, providing clarity on the CCJ role, function, organization, structure, and management. I don't know if you want to comment on what I refer to the awkwardness and how that can be how we can overcome that. You know of the efforts in Grenada, Antigua, and so to address that issue. It's a challenge that we face. I don't know if you just want to comment on that.
Yeah. Say for Grenada and Antigua that have particular challenges, I think all the other countries in CARICOM should subscribe to the appellate jurisdiction as soon as possible. In Jamaica, there's a heated debate on the issue. I know that of the 2 parties there, one is in favor of acceding. The other one, I'm not sure what their position is, but certainly countries like Jamaica, Trinidad, St. Kitts and Nevis, and St. Vincent and the Grenadines are disappointing cases because they only require a parliamentary majority, a 2/3 parliamentary majority, and to have to go through the indignity of asking for Britain's agreement in order to accede. But Britain will never say no. They will never not agree. It would be scandalous if they were ever to do so. That is the route that St. Lucia and the Commonwealth of Dominica took. And St. Kitts and Nevis and St. Vincent and the Grenadines should adopt that measure. In the case of St. Vincent and the Grenadines, it is possible that they can't get the 2/3 in Parliament, which is very regrettable. I'm not sure what the position is in St. Kitts and Nevis, but to my mind, it is important for our Caribbean jurisprudence that the entire Caribbean countries should delink from the Privy Council and subscribe to the court that they have paid for, and that I think has done a creditable job since its establishment in 2004.
Mm-hmm. Hopefully the notion that our Caribbean people are not as intelligent as the people from overseas. Hopefully, I think that we have conquered that, we have gone past that.
Mm.
And I think in many fields of endeavor, our Caribbean people, whether it's sports, culture, whatever it is, they have demonstrated we can compete and even triumph over the best in the world. And I don't think there should be any doubt that our scholars, or in whatever field, and in this case we speak about law, jurisprudence, I don't think that there should be any doubt as to that. I think the reservation is what Ruggles highlighted earlier, and hopefully we are moving in a direction to also conquer that.
Mm.
President Saunders, before we finish, and Ruggs, before we finish, I just want to once again recognize the sponsors of the program, Gel Professional Solutions, Gem FM carrying the program out of Canada, and Grenada Technical and Allied Workers.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Ruggs, I don't know if you want to come in before we hear the last one from.
Yes, well, I recognize that the time is up on us, but thank you, President Saunders. As I always advocate, public legal education is key, especially when it comes to the CCJ, because we are building something that is new. That is an area that people historically have faced challenges in terms of the justice system, with the delays in the justice system, the access to justice, the expenses involved, and therefore there are certain psychological issues that need to be overcome. Plus the issue, of course, of us having our own institutions, and as Bob Marley and others have emphasized this issue of mental slavery. Those who, because of our history, feel that once it's outside, especially once it comes from former colonizers, it has to be better. But I believe the region has already dumped that theory, because over the years we have established our own University of the West Indies, and the University of the West Indies now ranks among the top universities in the world, comparable to any university in the world. We have had our own law schools, established our own law schools. We have the Caribbean Development Bank, and it's again, the significance was not lost when the point was made that even in setting up our regional institution, the CCJ, the CDP played an important role in terms of mobilizing those initial funds, the $100 million to start the trust fund. But it's a work in progress. It's, again, 20 years, a landmark, and people are able to judge the court. Those who had doubts from the beginning and saying, well, listen, we're not too sure what type of court this will be, have 20 years experience of the court now, and the judgments have been hailed both in the original jurisdiction and the appellate jurisdiction. We haven't touched on it, but I know Justice Saunders, within the next few months, will be celebrating, well, first and foremost, is 20 years on the bench of the CCJ. I think the last remaining founding judge of the CCJ. So congratulations on that. and despite his youthfulness, will be taking his exit not too long from now, within the next year, I believe July 2025, because of the rules, despite the fact that he has not reached the age of retirement, but once you have served as president, and you have served 7 years, it's either 7 years or if you reach the retirement age first. But congratulations, I think we all recognize throughout the region that you have been doing an excellent job, not just at the bench, but in, promoting the court and advocating for the court. And we trust that with retirement, that will continue. Probably you'll be busier in retirement than you are now, like Justice Byron, President Byron. So thank you and congratulations on the excellent work being done at the level of the CCJ.
Yes, thank you very much, Ruggles, and thank you to Ewart as well. I think that this was a wonderful initiative, and we are always ready and willing and pleased to provide information to the public about how the court is run. So thank you very much for this opportunity.
Thank you very much to the viewers. Thank you to those who provided comments, both on the YouTube and also sent me direct messages. And thank you most of all to you, President Saunders. I think your appearing here really symbolizes and crystallizes the importance of our judges, our people who interpret our laws and adjudicate really being amongst the people. And this is really highly appreciated. And I think it's a good, it's a sign, of great things. And the way that we should live, because the law is really part of our society. It's there to serve the people, and we really do appreciate you are stepping down from the bench to speak to those who you make decisions affecting their lives. Thank you so very much.
Yeah, you're welcome.
Okay.
All right. All the best to you all.
Okay.
Thank you.
Yes. Thank you. Good.
Yeah.
Right.